Hello, my name is Enrique Gonzalez, and this memorandum provides legal guidance for XYZ Holdings, a U.S. investor planning to establish a data center in Monterrey, Nuevo León. As a U.S. investor, XYZ Holdings benefits from the United States-Mexico-Canada Agreement, which offers protections such as national treatment and safeguards against expropriation. In this memorandum, I will explain the key legal requirements, public permits, contractual obligations, and risk management tools that apply to this project. First, under the foreign investment law, the foreign investment investors are allowed to own 100% of companies in unrestricted sectors, and data centers industries is one of them. The project will be secure as a Mexican company, and its bylaws must include the Cláusula Calvo, where the foreign shareholders agreed to be treated as a Mexican national for the purposes of the investment. This clause also enables the subsidiaries to own land, even near restricted zones. Also, the legal entities to carry out the investment, the best legal vehicle is Sociedad Anónima de Capital Variable, or SADCV, which offers limited liability and corporate structure similar to a U.S. corporation. Since Monterrey is not a restricted border zone, the Mexican company can directly own or lease land without requiring a trust. This simplifies real estate transactions completely. Coming up next, the compliance and permits. XYZ must comply with various regulatory obligations at the federal, state, and municipal levels. These include incorporation, tax registration, labor obligations, and so on. The investment must be registered with the National Registry of Foreign Investment within 40 business days. It will also need permits for land use, constructions, environmental impact, and civil protection. These procedures are essential before beginning constructions and operations. Also, the private contracts, the company will sign several private contracts that should include land acquisition, lease agreements, construction contracts under EPC models, and service agreements for telecom and maintenance, and a power purchase agreement or a PPA. The PPA is particularly critical. It guarantees the delivery of reliable and cost-effective energy and must define terms such as price, duration, availability, and risk. Also, the labor and employment. Under the Mexican labor law, at least 90% of the workforce must be Mexican nations. Foreign technological specialists may be hired under work permits, and all staff must be registered with Social Security retirement systems. To comply, XYZ must register with agencies like the INM, the IMSS, Infonavit, and Afore. Internal contracts and policies should protect confidentiality and intellectual property. Key legal risk and expropriations. Lastly, the USMNC must address data privacy and investors' protection. The Mexican subsidiaries will pay a 30% income tax and 16% VAT through the US-Mexico tax treaty that can help reduce double taxations. Regarding expropriation, Article 27 of the Mexican Constitution protects investors by requiring fair compensation under USMCA. XYZ can pursue international arbitration after exhausting Mexican courts for 30 months, unless exceptions apply. This wall protection reinforces the security of the investment. To conclude, also, this memorandum provides a roadmap for a successful and legally sound investment by XYZ Holdings in Mexico. Thank you very much.